It is accordingly directed that while the writ petition is dismissed, liberty is given to the petitioner to file an appropriate election petition as per section so and so. And as mentioned above, the period of limitation has to be counted by excluding the period from the date of filing of the writ petition, that is 10/11/2025 till the passing of the present judgment. It is also clarified that the present order of dismissal is only on the ground of maintainability availability of statutory remedy in the form of an election petition. No opinion whatsoever has been expressed touching upon the merits of the parties of either of the merits of the cases of the either of the party. Represents can disposed of.
Deeply obliged, Your Lordship.
Item 13, in this case, my lord, I have been appointed shortly, but I have got no.
Shortly or recently? Short appointment will not do the purpose.
Recently, yes.
Recent, okay.
Now, my lord, this paper book was given to the earlier lawyer, but he has not given the same to the party. So, Lordship, may kindly we will take a Xerox copy.
Okay.
Otherwise, they may not give.
Now we'll see why is it for orders? We'll see, have to see the
I have
record.
discussed with my learned friend.
There may be a private response.
He has also no, as told, he has also no papers. So we will collect.
Now, who is the respondent number 2, madam? Bora?
Your Lordship, actually, in fact, I'm handicapped with a copy.
Now we'll see the record. We'll accommodate your prayer, but we'll see the
Yes,
record.
I perhaps along with the criminal appeal, Lordship.
I is there and there is a second
No,
respondent.
IA is not considered. It is said that the main case would be
Oh,
hard.
there is a second respondent. We do not know whether service is complete or not.
Lordship.
The conviction is under what? POCSO?
Pokso.
Then there will be requirement.
Informant.
Yes.
If served, not appeared, then we'll appoint an amicus. If not served, we'll have it served. Let it reach.
I am in custody since
No, let it
3
reach.
years, 3 months.
Let it reach. We'll, even if you're not there, ask your colleague to be here. Okay.
For detailed accommodation, Lordship, can I pray? Lordship?
Item number.
Item number 9 can be taken up as the last item. Lordship.
Today, this bench is rising early.
Yes, I know, Lordship.
9, it's an admission matter.
We have, Lordship, where this matter is relating to bail in a unlawful activities act.
Admission.
Yeah, so Lordship, your Lordship can dispose of because this is only for bail. My bail application was rejected by the trial.
Without giving them an opportunity. They'll have
I
to
will
appear.
take only, Lordship, 5 to 10 minutes, your Lordship. We can, I think.
We'll accommodate you.
Yes, Lordship. Immediately, last item.
May I please, Your Lordship? I beg to mention for listing one IA criminal lordship for bail lordship
Okay.
in orders column lordship. Monday
When?
lordship,
Monday may not be possible. We'll do it on Wednesday.
Tuesday lordship,
No, not
Wednesday.
Wednesday.
Deeply obliged lordship.
Yes,
Let me
ma'am.
also, I take to item number 27, my lord. Yesterday, one of my colleague, Mr. Ahmed, made a mention to that regard, my lord, for listing for orders column. But unfortunately, it is listed in hearing column, my lord. Lordship may take up as orders after completion of the orders, my lord,
Hearing? 17 matter, what orders? We'll hear the matter.
today. my lord.
Today,
I
if
leave
it's
up to-
possible today, otherwise we'll have it some other day. Today, second half, we may not be able to sit. Second half.
NCs. Worship, I have been appointed as a counsel for the NCB.
Okay.
Worship, I did not have the records. I have taken a copy of the paper book from her today. If it
Paper book
can-
you have taken.
From her today.
Then 17 matter, she's also having an
My lord,
early.
here what
Next
problem?
Tuesday, can you have it on Tuesday?
That's fine.
Tuesday.
My lord, what happened in this case? 12 years conviction was
Tuesday hearing.
Tuesday may not be possible. Can it be
Wednesday?
Wednesday?
Wednesday, okay.
It's fine.
So 12 years, 10 years completed, my lord.
We'll have it on Wednesday hearing. On a joint request made on behalf of the parties, list this matter for hearing on, this will be on, 1st of April. Okay.
Here one IA is there, lordship.
No, we'll have the entire matter heard
Mal-
1st of April.
My lord.
Paper book is prepared.
Paper.
Okay. You collect
Already-
paper book.
So many times heard by the court also, my lord.
I received a copy from.
Okay, 17 matter, we'll give preference to this.
My lord.
Okay, Mr. Day?
Obliged, your lord.
Lordship, in item number 14, Mr. S. Bodhak will appear, Lordship, for the appellant. But he had to go out of station for some personal work today, Lordship. So may I kindly pray that it is taken up on another day?
Okay, other side inform, madam?
Yes, sir.
on a request made on behalf of Sri S. Botaku, but it is for orders. Why orders?
The IA is there, Lordship.
Okay. Otherwise respondents have been served.
Yes, I'm for respondent number two.
Two, okay. On a request made on behalf of Sri S. Botaku, learned counsel for the appellant applicant, matter is adjourned to be listed on
Any date, Lordship.
Wednesday next.
Or after the vacation, I think, paper book,
I have not received the paperwork, Lordship.
Paper book you have received.
Lordship, we have also not received. We'll
The
take a
paper book is
copy.
prepared or not?
Yes,
Yes,
please,
yes,
Lordship,
prepared.
it's reflected in the.
To be listed immediately after the Bihu vacation. In the meantime, paper book, copies of the paper book may be furnished to the learned counsel for the parties.
Much obliged.
Ms. S.H. Bora, learned APP, and Ms. D. Ghosh, learned counsel for respondent number 2 are present.
You will receive the paper.
Yes. Jail,
Please change that.
under,
Petition is not before us, Lordship.
you should check the records, at least know what are the conviction under.
So, correct.
POCSO হবো, হ্যাঁ?
20 years.
POCSO হলে appeal from the admit, call for the records. One, madam, or S.H. Bora. That to be taken for service of notice upon the informant victim to be received through the office of the censor. And we appoint an amicus.
Lordship.
Of the list after amicus who 32, huh? Serial number 32. Amicus also list on the to read. 7 list on 6th of May, 6th of May, along for service of records as well as receipt of records as well as service of that one number informant victim informant. Name of the amicus to be reflected. Okay, is into order here. Same. Okay, madam. We fixed it on 6th of May.
Lordship.
You bring a report on service.
Same you can, Lordship, given if you give.
POCSO, same order. You give 36 number, no? So Baki said 36. Okay. Admit, same date. Legal aid counsel.
Yes, Lordship. The appeal has come up for admission. He has been convicted under POCSO, section
So-
4 of the POCSO Act,
Okay. I do-
and
POCSO
imprisoned
heard
imprisoned
you
for
to-
25 years.
You Chaudhary, huh? Learned legal aid counsel, who has preferred the appeal, so admit Baki sir, okay? Although, ইয়াতে খালি steps ল'ব হেৰি through the office of the PP, learned PP Assam. আৰু next day take থাকিব, বাকী next day take থাকিব, আৰু day take থাকিব, and the IA hired Sri so who has filed this application. The connected appeal has been admitted today. Issue notice. One by madam. 2 steps through the office of the PP. List on same date.
Obliged, Lordship.
Item for matrimonial.
I'm party respondent.
You are Mr. Motok?
Yeah.
What? Okay. Where is your colleague on the other side? B. Pal. Who is B. Pal? DP Bora. DP Bora. Where is Mr. DP Bora? Dipankar Bora. Matt appeal. Mr. Bora, where are you come? Yeah, matter.
Yes,
We admit this.
And my lord, may I make one submission? Because my lord, the main allegation is that the wife left the house of the husband. So he, as of now, wants that if she comes back, my lord, divorce, the question of divorce doesn't arise. So let them come, and if she wants to come back, because she doesn't want to come back for last till the year, since the year 2018, my lord, she is staying in her mother's place, my lord. And that evidence, my lord, the evidence of the wife has been appreciated by the
When was the marriage?
2018, my lord.
18. You have an issue.
No, my lord.
Future.
After staying only 13 days, she left, my lord.
Mr. Motam?
I'm not yet got the appeal member, my lord.
No, that is okay. But you take instructions whether
Uh,
you are willing to have a matrimonial life with.
We have no objection in admitting this.
No, we'll admit it, but we'll try for mediation. First, you appear.
Yes, my
before us,
lord. That's
okay?
I agree.
Third,
Yes.
Sri D.P. Bora, learned counsel for the appellant, who is aggrieved by judgment dated judgment and order so-and-so, passed in so-and-so, by the so-and-so. By the aforesaid judgment, the petition filed for divorce has been dismissed.
Yes, my lord.
Para, admit, call for the records. S. Motok, learned counsel, has entered appearance and accepted notice on behalf of the sole respondent. You have been served copies? Letter copy
Yes,
of
my
the
lord. I will
appeal
serve a copy.
be served upon him. List on he's already appeared. So we can have it on 22nd of April.
Yes.
Okay. 22nd of April for a report on receipt of the records. On the same date, this court would also explore the option as to whether the matter can be referred for mediation.
Obliged, my lord.
Indication to the five.
My suit for divorce was dismissed, my lord.
Good for divorce. You are the husband.
I'm the husband, my lord.
I Chaudhary, huh? Same. I Chaudhary. Baki khane aake do. It also admit, call for the records. Let steps be taken for service of notice upon the respondent by speed post lit AD. Steps within 2 days. List on accredit for service report on service of report on receipt of records as well as service report.
Right.
Item 6.
My lord. I am correspondent on behalf of SNO Depot.
Okay, who is for the petitioner, Matt appeal? P. Borua, Miss P. Borua. Who is P. Borua? P. Borua?
Respondent, Meenakshi.
No, that we have
I am
understood.
on behalf of respondent.
Resolution was
The
allowed.
appellant has not submit memo appeal.
No,
Therefore,
the counsel for the appellant is not there.
Therefore,
We wait for a while. Please wait for a while. If
Therefore, I
he or
request-
she comes, we'll pass orders. Otherwise, we'll have it on the next week. Okay, please wait for a while. কোন বা P. Borua?
Next week.
আহিলে পড়ি না, অ্যাড্রেস পড়ে দেবেন। Matt appeal.
Item 7.
Section 30.
302. Into 302 হবো, হ্যাঁ? DL appeal. এটুক খালি second respondent না থাকে আৰু, হ্যাঁ? Admit সবখিনি কবা আৰু and my customer dealing. So, serial number 4. Numbers. Okay.
May I please, His Lordship? Lordship, this is a jail appeal, Lordship, convicted under section 6 of POCSO,
You are a legal aid counsel.
Lordship.
Okay. Deep or Pujari, huh? Legal aid counsel. That's the you Chaudhary. Yeah, report to Asinti Ane. Number 2, through the steps through the office. Date, same date. Same date. Okay. You have to take steps through the office of the PP. Mhm. Nine to typing a silicon. Yes, Mr. Sharma.
Section Fox.
POCSO.
Yes, Lordship.
Okay.
20 years imprisonment,
20 years.
Lordship. Section 4.
SJ Sharma, huh?
Yes, yes.
Or it or jail appeal, normal. For the appellant who has preferred to admit or in the IAU, same order. This is an application praying on the so-and-so. A connected appeal admitted, issue notice, Madam 1, and respond number 3. That's an agreement.
Published.
You bring a report on the next date regarding service of notice. Dated.
This is appeal against conviction under section 6 of POCSO Act, my lord. This matter may be admitted, my lord.
Okay. Your Deborah.
Yes, my lord.
Deborah, huh? Okay, so I had issue notice for it, connected appeal admitted, issue notice.
This
Yes.
open I, my lord.
We issue notice.
Obliged, my lord.
May I please, the appellant convicted under section 4 of POCSO Act, Lordship.
4. What is your name?
B Islam, Lordship.
B Islam. Okay. You have to take steps for R2 through Madam.
Lordship.
Date kiman disu? He did this all over. Huh? 22 dia na. Eta agor admit bila. 22 to all 2 party asile. 6-5. 22 to net appeal to other side asile.
6 of May.
Yes, 6.
Much obliged.
We think TCR may be called for.
You have called for. Admit, call for the petition.
Until 24 and 25. Oh, sorry.
Order
13.
Until 13.
Yes, you had some
Yes,
prayer.
but, my prayer is this, the earlier lawyer, perhaps, I have no personal idea, collected the paperwork. So kindly a paperwork may be provided to me. And as I am in custody since last 3 years, 3 months, and fixed period imprisonment, so matter may kindly be fixed on Tuesday for hearing.
No, what about respond number 2?
Respondent number 2, because at the time of rejecting the bail application, it was
You
considered.
have to bring a report. There is no report. Madam, it's POCSO. Last it came in 2024.
Despite several attempts could not be found.
If at all he or she does not appear, We'll appoint an amicus.
There's a report is fixed, my lord, then it is Lordship may appoint.
Several attempts, despite several attempts, could not be found at that place.
You cannot say they.
So then, my lord, amicus curiae may kindly be appointed
I have the honor
Date
to
we have to
report.
see the date.
today itself.
This is 24. You have to see the order of 3-4. You see the.
Yeah.
This was taken into consideration thereafter. Additional PP submission endeavor will be made to serve notice. But still then we can appoint an amicus. Third, Sri M.U. Mahmood Learned Counsel for the appellant, who has submitted that he has been engaged recently. Also heard Miss B. Bhuya Learned APP. Perusal of the order dated 3-4, also perusal the order dated 3-4-2024, along with the communication dated 2-4-2024 of the concerned, issued from the concerned Bongaigaon PS, wherein it has been stated that despite numerous attempts, the respondent number 2 could not be served. Since the conviction and sentence involves the POCSO Act, we appoint.
And so on.
This confirm.
List has come, my lord. New list of amicus has come.
Two list.
New list, my
New
lord.
list.
Dated 23 to 2026. Ekon দিছে ন দাদা?
New list.
Twenty-five. 21 on the boxing about 25. What's the date? 25. We appoint to Madam Morami Pathak. Morami Pathak, 25. Huh? Let copy of the paper book be served upon the learned amicus curiae, whose name is also to be reflected in the cause list. Put stop. You
And-
collected a copy?
Yes, that may kindly be reflected, otherwise registry may not give.
No, another copy may not be available. You have to make photocopy.
Yes, I definitely I will do, but
You can take it from Madam.
No, Lordship, not there. Probably our office has not provided us. They misplaced it.
Okay,
at times.
The Mahmood, the learned counsel, prays for liberty to get the paper book photocopied at his own cost. Full stop. Office to facilitate the same. Full stop. Let this matter be listed for hearing. When?
Thursday, my lord.
Thursday it will not be possible. New amicus will not even be served.
No.
We'll have immediately on the reopening. We'll have it on 21st of April. Is it okay?
May it be a little upgraded, my lord.
No, the earlier week is a vacation, Bihu,
Last week is.
and last week is
trunk-
motion will be
3
difficult.
days only.
21st or 23rd, whichever date suits you. 21st or 23rd,
21st,
April or 23rd April,
21st.
21st April. But ensure, Madam, you also, Madam Bhuya, please ensure that amicus is
So,
informed.
yes, ma'am.
Morami Pathak.
Morami Pathak.
Is she regular in the court?
At times I see her. Lordship.
You take her number, it's in the.
Yes,
Actually, the paper book, after it is prepared, they must be doing it. I'm not sure. They should scan it
yes.
and keep it. So whenever you need another copy, you can just take out a print. If I will, yeah.
Lordship, may we also get a copy?
Right.
You see, আমি কি লিখিলি এইটো? নহয়, collected of কি বুলি কয়? Paper book যে কলো, office to facilitate. তাৰ আগত. As well as Miss B here.
My lord.
Paper book পোৱা নাই।
15, Mr. Kolita, amicus.
My lord, yes, I was appointed initially as a amicus, my lord, but I have not received the paper book.
And I represent appellant actually.
The appellant has engaged the counsel, so let him argue.
Yes, yes, my lord.
If we require your assistance, we'll.
My lord.
Okay, Mr. Ali,
Yes.
paper book has been prepared.
No, these are 4 files.
It's come for the first time after admission.
Maybe by order it is come.
It was last heard on 24 November, I think.
Okay. Yes, you're correct. Though this appeal was preferred from jail and was admitted on 29/11/2024, whereby an amicus was also appointed, Sri I.S. Mazumdar.
It is not there.
No, you're not. Sri I.S. Mazumdar, Learned Counsel has submitted that he has been engaged by the appellant. Full stop. Record the he said. What about respondent number 2? Respondent number 2 has been served. Yes, have you taken a report? Since the records have, no, I'm not written. Ms. B. Bhuya, Learned APP, has however submitted that the report regarding service of notice upon the respondent 2 is not readily available, and she accordingly prays for some time to obtain the same. Full stop. While time is granted to the Learned APP to obtain the report, registry is directed to go ahead with the preparation of the paper book. List, we give a date. List on 29th of April to enable the Learned APP to furnish the report.
Police station to be.
It's Dispur, I think, Dispur PS. Give her the details.
Yeah.
Okay.
I will get it.
Or you can check the records.
No. 16.
May I please, Your Lordship, this is appeal against conviction under section 302, my lord. We have received the objection from the learned PP, my lord. So there is a IA, my lord, that may be taken after the preparation of the paper book, my lord. That will be convenient.
Records have been received.
Yes, my lord.
Heard Sri D. Bora, Learned Counsel for the appellant, as well as Miss B. Bhuya, Learned APP. Full stop. The appeal was admitted on 28/2025 and pursuant to the order of calling for the records, those have been received. Full stop. There is also an IA praying for suspension of sentence. Full stop. Para. The Learned Counsel for the appellant has submitted that the IA would be pressed after preparation of the paper book. Full stop. Para. We accordingly direct the office to prepare the paper book and list this case immediately after such preparation and furnishing of copies to the Learned Counsel. Who's 2? In a 302 case. Okay, take us. Your name is shown on Mr. Deuri?
Sure.
Sri T. Deuri. That's one number 2. APP for the state and Sri T. Deuri for one number 2. Okay.
Obliged.
Item 17.
Appeal to the Maria. Appeal to Maria, to the Maria. Yes, madam.
Report we have received.
My lord. POCSO matter, my lord.
Yes, sir. That is it.
Soft. Okay. Conviction under
Under 6 of POCSO, Lord.
POCSO, so we'll appoint an amicus.
Fine.
Lordship.
What is your name?
B. Borgohai, Lordship.
Heard Sri B. Borgohai Learned Counsel for the appellant, as well as Ms. B. Bhia, Learned APP Assam. First up, this appeal was admitted and TCR call for wide order dated 27/8/2025. I say records. In terms of the said order, comma, the records have been received. First up, para. That paper book be prepared. Para. Ms. Bhuya, the learned APP, has however informed that she has received a written communication from the concerned Harmony outpost that the respondent number 2, due to financial crisis, is unable to engage a counsel. Put up. We accordingly appoint legally legally amicus. Legally the civil legally আছে তো legally
পুরোনো এখন নেই নাকি? পুরোনো লিখে দিত।
legally এখন বিলে আছে legally
Both can be used, right? Both lists can be used.
ওই না কই তো legally legally আছে anyone legal aid counsel in the court? Yes, appoint Miss B. Sharma, learned legal aid counsel, to appear for the respondent number 2. Let the name of the learned legal aid counsel be reflected in the cause list. You take note of this case.
My lord, that may be fixed. The IA is there, Lord.
List immediately after preparation of the paper book. IA, we are still alive. We'll consider the IA. Okay,
Can I be fixed on 28th of April?
but paper book will not be there. If you say we can have the IA listed, but will it serve any purpose? POCSO,
Lordship.
without going through the records, it will be difficult for us.
Lordship.
Let the paper book be prepared.
Must.
You have a copy, madam, of this?
Yes.
18.
Please, Lordship. In this matter, also, my lord, the TCR has been received, my lord. And my lord, maybe this is after preparation of paper book, my lord. And IA will be pressed on preparation of paper book. POCSO matter.
Okay. Heard Sri M.J. Kadir, learned counsel for the appellant. What about the respondent number 2?
He's dead.
Okay. As well, appellant also heard. Full stop. Also heard Ms. B. Bhuya, learned APP, and Sri R. Ali, learned counsel for the respondent number 2. Full stop. Pursuant to the order dated 24/10/2025, the TCR have been received. Let the paper book be prepared.
Yes.
And the matter be listed immediately.
Yes.
After preparation of the same and furnishing copies to the learned counsel for the parties.
Problem. Okay.
Lordship, the matter may be taken up after some time. Obliged.
Section 5 limitation. How many days? 8 days will condone this delay. Madam, you are for whom?
Lordship, I'm appearing on behalf of
FC.
Mr. P. Saikia, legal aid counsel for respondent.
Will condone this delay. What is your name?
R. Mali on behalf of S. Das.
Heard Sri R. Mali, learned counsel for the applicant. Also heard Miss
Yes, Dave.
as the learned counsel appearing on instruction of Sri P. Saikia, learned legal aid counsel for the respondent. This is an application under section 5 of the Limitation Act 1963, praying for condonation of delay of 8 days in filing the accompanying revision petition. Full stop. The learned counsel for the applicant has drawn the attention of this court to the averments made in paragraph 4, 4, 5, and 6, and has submitted that due to reasons beyond the control of the applicant, the delay has occasioned. Full stop. You are having any objection? The learned counsel for respondent has not raised serious objection to the aspect of condonation of delay and has submitted that the contest would rather be made on the merits of the case. Para? Considering the above and also the settled law that an application for condonation of delay is required to be considered in a pragmatic and justice-oriented approach, comma, the delay, which is of only 8 days, is accordingly condoned. The IA stands allowed. List the connected appeal be registered and listed in the next week.
Highly objected. Lordship, a date may be fixed.
It has to be registered. We cannot exactly give the
Yes,
date.
yes.
Okay, registered in. Yes, madam.
Yes, Lordship. Trial court record was called for.
Hmm?
Trial court record was called for, Lordship.
Trial court record.
Yes.
Okay. I see.
Yes, it is, Lordship. Matter will be fixed for hearing, Lordship.
Other side, you have appeared.
Yes, Lordship.
Madam, your name?
K. Bhrali, Lordship.
Heard Miss K. Bhorali, learned counsel for the appellant. Also heard your name?
Yes, Ali.
As Ali, learned counsel for the respondent. Full stop. Para. Pursuant to the order dated 19/2/2026, the TCRS have been received. Full stop. Let the paper book be prepared. And after serving copies to the learned counsel for the parties, the matter be listed.
Much obliged.
Lordship, delay of 85 days, 302 and 448.
First day,
Lordship,
we'll issue notice, we'll condone the delay. Please, how many days? 85 days.
85 days.
Okay, we can condone the delays. Okay, 302. Okay, heard. Miss B. Sharma, learned counsel for the applicant, who by means of this application filed under section 5 of the Limitation Act 1963 has prayed for condonation of delay of 85 days in preferring the appeal. Full stop. Also heard Miss B. Bhuya. No, এটা নিয়ে লিখিব পিছত লিখিব না ঠিক আছে also heard Miss B. Bhuya, learned APP Assam, para. Miss Sharma, the learned legal aid counsel.
Lordship,
Upper legal aid counsel লিখিছে না B. Sharma legal aid counsel. Miss Sharma, the learned legal aid counsel, by drawing the attention of this court to the averments made
paragraph 4.
in paragraph 4, has submitted that the delay has occasioned because of reasons beyond the control of the applicant. Full stop. Ms. Bhuya, the learned APP, has not raised serious objection to the aspect of condonation of delay. Full stop. We condone the delay. Okay. I go to the delay. The agot khali revision appeal be registered and listed for admission thereafter. Okay. Delay conduct, I dispose of. Mr. Panikor,
My lord, 84 days delay, my lord.
your legal aid counsel.
No, my lord.
Conviction under POCSO.
Also, my lord, but
20 years.
The son is the child is born, my lord, and both are living with me, my lord. In my house. That's not a Romeo Juliet case will apply, my lord.
Hmm?
That Romeo Juliet case, my lord, that was referred by the Justice Koteswar Singh, my lord. That was applied in this case.
Okay,
Yeah,
we
84 days when it
we'll
done.
have to issue notice. There's a private respondent.
Madam.
Private respondent is staying with you.
But
Stay
no,
with-
no, my lord, is the father, my lord.
Informant is the father.
He reserved informant is the father.
You could have made the victim an party. It would have been easier for you. Victim is your wife now.
No,
It would have been
and there's
easier.
a side matter to that was also living with me.
Huh?
20 years.
How many days?
84 days.
I will issue notice. Third, 3 chronic or learned transit for the applicant who has filed this application under so and so, praying for condonation of delay. Section 5 just delay of 84 days in preferring the appeal. Let notice be issued. Miss B. Bhuya, learned APT except for 1. 2 to go tomorrow. Notice upon respond number 2 to the office of the APP of PP Assam. Steps within 2 working days. List on, we give a date.
And the last week of April,
List on 30th of 29th of April to enable the learned APP to obtain the report regarding service of notice upon the respond number 2 as well as to file objection if any.
Diplo.
So there is delay in filing the connected appeal, your lordship, against acquittal, your lordship.
Against
8 days
equity.
of delay.
How many days?
8 days.
Equitable, but notice will have to go. Third, Dr. R. Sharma, learned counsel for the applicant who has filed this application under section 5 of the Immigration Act, praying for condonation of delay of 8 days in preferring the appeal. That notice be issued. Madam for 1. 42 by through the.
No, may not be through us, my lord.
It's under what? 376. Oh, sorry.
To the accused earlier.
1 and number 2 by in the usual process. Steps within 2 days. List on 29th of April along with for service report as well as service as well as for filing objection if any.
Obliged.
24 and 25 subsidies.
May it please your lordship, in this matter, my lord, I have received the paper book. Matter is otherwise ready for hearing.
Prabhu, we have received, my lord.
Received.
POCSO.
Fox.
Respondent.
Notice are received into 100 number case.
Oh, lordship. Service complete.
You have a note.
Other date probably I have submitted, your lordship. It's updated 20 to 2026.
Maybe in next case.
Ujjwal, U. Chaudhary has been appointed. U. Chaudhary, where is Mr. U. Chaudhary? Name not shown. Is Mr. Chaudhary there?
Name is not shown.
Lordship, in item 25, we have taken steps. Monica Bhumi's matter. Therein the.
There are two matters.
Yes, connected.
Out of the same case record. my
In
lord.
your case, madam, we see that for respondent number 2, U. Chaudhary has been appointed. He is not there. His name is not. In your case, who is appointed?
My lord, amicus, my lord.
Name not shown.
Has anybody been appointed, Mr. Doctor?
Same
In our case, the
Same
notice.
comment, my lord.
Notice was yet to be served by that, so
No,
the point.
লিখাটো হৈ গ'ল। লিখাটো তুমি
Complete hoise, complete hoise.
Yes.
The victim is the same in all both the cases.
In both the cases, we are appearing for the victim, victims, my lord.
No.
Accused, my lord.
Same.
But informant is the same.
Same.
person,
So
person.
Mr. Chaudhary can amicus would be.
Lordship, he
Where is
can-
Mr. Chaudhary? He was around. His name has not been reflected, so he may not be knowing. Please inform him. We can inform so that he can keep track of this. And
Right.
paper book is prepared. We can go for the hearing of this matter.
Yes, paper was furnished, madam.
I will inform him, my lord.
Heard Miss M. Bormon. Amicus curiae. And as well as Sri M. Dutta, learned amicus curiae, appearing for the appellants in these two cases. Full stop. Do Sri U. Chaudhary, learned, also heard Miss B. Bhuya, learned APP, Assam. Para. Do wide order dated 13/3/2026, passed in both no 96 96 or about 13/3/2026. Sri U. Chaudhary was appointed as amicus to appear on behalf of the respondent number 2, comma. His name has not been reflected in the cause list. We have also noted that the paper book has been prepared and the matters can be listed for hearing. Full stop. Accordingly, we direct that the matters be listed for hearing in its turn, on their turn, was the name of Sri U. Chaudhary be reflected in the cause list. Please inform him.
Lordship,
Because next date, if it listed, if his name is not there again, refer to
I will inform. him.
Oblige, Lord.
Oblige.
name to devote Luna, cause list.
Item 26.
Right.
Wait, please, Lordship. Lordship, 152 days delay in filing the criminal appeal. This is for seeking bail, my lord. Order dated 26/8/2025.
Notice has been issued.
Not yet, my lord, since the appeal has not been admitted because of the delay.
No, delay notice has been issued or not?
They have appeared, yes, sir.
Okay.
Would like to bring to your lordship's notice, section 21 of the NIA, second proviso. There's a limitation of 90 days beyond which the delay cannot be condoned. Let's
Okay.
place 1 minute. Please.
Is there any provision for condonation? No. So it's a special statute.
My lord, there are some judgments. In fact, my lord, in the state of Jammu and Kashmir, the NI itself have gone against this proviso, and they have been asking for condonation of delay of 146 days, which the court allowed. In one state, my lord, they cannot ask that there is a proviso and they cannot go for the delay condonation. In another state, my lord, they themselves are filing against this section. I have those judgments, my lord, here.
I filed my.
Objection is there, my lord. If the objection is on record, then my lord, I may pursue those judgments.
Objection is there.
I filed it yesterday, lordship.
Objection is not there. Has not been received. You have the objections on record. On Tuesday or Wednesday, we'll consider this.
Lordship.
My lord, on the
30
7th,
days.
if I may pray.
Period is 30 days.
30 days, that may be extended to 90 days, and then there's a proviso which says shall, but that is to be construed as may, my lord. That is all the judgments I've been saying. Because, my lord, in ST Atrocity Act also, there is no provisions for delay filing, but there has been judgments in which.
These have to be interpreted keeping into mind the objective of the act and what is the his approach to the court as a in the appellate. You have filed an appeal.
I filed an
Against
appeal.
rejection of bail.
Against rejection. So the question of personal liberty is concerned. We may have to take a different view, which we may not take in a 34 petition, like of the Arbitration Act. It depends. But we'll definitely okay. Heard Sri J. Singh, learned counsel for the applicant, as well as Sri R.K.D. Chaudhary. You appear as Deputy AGI?
Yes.
Deputy AGI. Full stop. Sri Chaudhary, the learned Deputy AGI has informed that written objection has been filed on
Yesterday, lordship.
filed yesterday, which however is not tagged with the records. Full stop. Let the written objections be tagged with the records and the matter be listed for consideration on first or when?
My lord, as per your convenience.
Whenever you say first, I think Wednesday will be good. First of April.
There's no Supreme Court judgment on this point. No.
There has been some interpretations, but
Interpretations,
all
but
different
no.
high courts have
Yes.
different views. But mostly when it comes to the liberty of the
True.
applicant,
Yeah.
my lord, here, then the views have
You have to
always
see
been
the
construed to
application
really-
of section 29, I think, 2 of the Limitation Act, right? Whether if the limitation period is there, whether 5 will apply. To some extent, 29 might also come.
Yes, yes.
And usually if the extension, if the extended period is incorporated in the section itself,
Yes.
usually it is considered a complete code. But this is a question of liberty that is also there.
Yes. Six, we'll have it some other day. Okay, none appears for these. 6 is for what?
None appears matrimonial.
None appears for the appellant on call, whereas your name?
Vikramjit Boro.
B?
Vikramjit Boro. B Boro.
B. Boro.
B. Boro.
Learned Counsel, you are on record or not, Mr. Boro? No.
Still not.
Whereas Sri Boro, B. Boro, Learned Counsel has appeared on instruction of Sri SN Adapok.
It's not to go.
Para, in the interest of justice, matter is adjourned to be listed after a week.
Obliged.
No, it has heard. This matter was, this matter was called up when there was no representation on behalf of the appellant. First, the matter was called up again after completion of the matters, and still there is no representation on behalf of the appellant. That's what B. Boro, B. Boro, how much I did. Very follow the time of it. Yes, next.
I can 28 to 29.
পুনানি হয়েছিল আলু পাথর পাথর
Who matters? One, Mr. Alim is appearing, right?
Yes, I am appearing in 28.
Mr. NM Deca. Miss NM Deca.
The other day also,
Family members.
we were hearing only Mr. Alim. NM Deca was not there.
My lord.
So we asked Mr. Goswami on the respondent that his presence may not be required. In his case, Goswami is not a party. We'll complete his matter. What is the other matter? Same
Who is this
grievance.
person?
Grievance is against the same judgment.
Same judgment.
So why is the private respondent there?
Mine is on against conviction,
No, the other is against acquittal.
against acquittal.
It's a different matter. We'll hear it differently. We'll complete his matter. Segregate. Liberty কথা আছে।
Against the author, probably accused, lordship, acquitted person have to be heard, my lord.
Who?
No, as
No,
I
he is against conviction.
No, there are two. Your
The other is
splitting
against,
up.
others will split up.
Seems so.
Well, no point causing prejudice to him. He is behind the bars. Somebody is against somebody's acquittal. If he is not there, will not hear that matter. Okay. The other day, your colleague was there, Madam Begum.
On last occasion, we were on the evidence of deposition of the victim injured, I think.
Just a minute, just give us 2 minutes.
Yes, yes, I mean, there is a maternity leave.
No, that will not take it.
Yes, yes, yes. See.
So we are on PW 5.
Yes, my lord.
Correct? And PW 5 is of significant importance because he was also injured. Injured. Okay.
Yes, my lord. Before further submission, I would like to bring one thing to your lordship's notice, that my points are the eyewitness not examined, then the chronology of the attack.
Now, first you complete let us say, complete the PW 5.
No, I am not elaborating my submission.
Yes.
I am pointing only because of that during reading of deposition, your lordship may point out that particular point. That is why I am submitting. The chronology of the attack, the chronology of the place, inside or outside, and the medical evidence. Medical evidence I will submit separately. And the vital eyewitness, the little child, he was present on the spot. There is a solitary witness, eyewitness here in this case. So his evidence has not been recorded. So I am coming, my lord. Let us go to the deposition of PW 5.
17.
17, my lord. I know all the accused persons. The deceased Vishaka Vishwas was my wife. The incident occurred 6th day of the month of Toth in the year 2010 on a Sunday. At about 9 p.m., the incident occurred after taking our meal. Kindly note this particular point. Why I am submitting, I will come later on. At that time, after hearing a sound outside our home, my wife Vishaka first came out. So lordship, kindly note that his wife came out from the house, followed by me. He also followed. At that time, Tirtho, Mohanbashi, myself, my lord. Mohanbashi, I am not. Shonabashi, myself, my lord. Tirtho, Mohanbashi, Shonabashi, Narayan Sarkar, Manik Singh, Priyonath Singh assaulted my wife with dagger in her neck. So here clear implication against all the accused persons. Stomach, face, and thereafter also assaulted me with dagger on my forehead. So the deposition of this particular witness is clear that he was attacked with dagger. But the medical evidence clearly says that he sustained injury by blunt weapon.
Dagger, there is there is blunt side on one of the edges.
Yes. And also on my hand. So he has got injury on forehead, chest, stomach, and hand all over the place by blunt weapon. Cannot be, my lord. If one injury is there, then it might be that the blunt side has been touched. Then, my lord, I was first assaulted by Shonabashi. Kindly, lordship, note it. I was first assaulted by Shonabashi. Myself, my lord. Here he says before court that he was assaulted by Shonabashi first on my stomach by dagger. The accused Priyanath also assaulted with dagger on the chest. At this stage, the witness, by removing his shirt, has shown the injuries to the court. The accused Manik Singh has assaulted me with dagger, though he attempted to assault on my neck. I have seen my wife being assaulted first by Tirtho. So here he says that he has seen the assault which was made by Tirtho to his wife, the deceased, with dagger, and then by Mohanbashi, and then by Shonabashi. I am third, my lord, with dagger. My wife was also assaulted by Narayan Sarkar with dagger. Tirtho Vishwas is my younger brother. My injuries were attended by doctor at Mangoldoi Civil Hospital, and thereafter I was shifted to GMCH, where I was treated as an indoor patient for 10 days. Lordship, kindly note that he has implicated all the accused persons. Now, during cross-examination, what he stated. Police recorded my statement at Mangoldoi Civil Hospital after police was called to the hospital as I was in a serious condition. So, he was in a serious condition in the medical. Whether he was in a condition to give deposition or not, that I will come later on, my lord. It is not a fact that in my 161 CRPC statement, I have not stated that Narayan Sarkar, Manik Singh, Priyonath Singh had entered into my house on the day of occurrence. He did not state it before police, but in the court he has introduced this particular fact. It is not a fact that I have not
No, he has
stated.
denied this. 161 perhaps did not have, but he has denied this.
He has denied it.
Contradiction, he has denied this. He has not
So my
admitted.
submission that he has introduced this particular fact before the court only, as because he earlier did not state it before police. It is not a fact that I have not stated before the police that Sonabashi, Narayan Sarkar, Manik Singh, Priyonath Singh, etc. had assaulted my wife with dagger. He denied that he did not state so. It is clear that he stated. He stated before police, but the evidence of police will say that he did not state so. So on the court doc, he blatantly stated a lie, Your Honor.
Mr. Alim, these are contradiction put to him. If he admits the contradiction, then it will be contradiction. He is not admitting.
Well,
Police
my
statement-
submission is that.
Police statement is not evidence. You can confront.
Yes,
If
and
he
is
says that yes,
confronted.
I have not stayed before the police, then it becomes a proof contradiction. It is not a proof contradiction. He has denied it.
No, my lord. It is not a fact that
He has
I have
denied
not
it.
stated.
Yes.
That means he has
So
stated-
he
Yes,
stated.
he has stated.
But he is not. He has not stated.
That is your version, Mr. Alim.
No, that is confirmed by the IO.
IO will only confront him by the 161 statement. This is 161 evidence. If he says, yes, I have not stated, then it becomes a proof contradiction. There is a difference.
No, my submission.
We
want
have
to-
understood your submission. It's not the first time that we are hearing this kind of a submission. There are two aspects. One is a proof contradiction, one it is not a proof contradiction. This is a contradiction.
I am not on proved and not proved, my lord. I am
We
on
have
that.
understood that he has denied it. You said that he had not stated this before the police. That's all.
No,
But
no,
it's not proved.
my submission is that he, standing in the dock, stated a lie. That is my submission.
So 161 is a sacrosanct truth. 161 writing the sacrosanct truth.
161 not proved by
Then-
IO's version.
I was deposing only on the basis of 161.
Yes, my lord.
Does he have personal knowledge? If IO has written the 161 by himself, 161 are not evidence. That is only for confronting. He might say yes, he might say no. He has said no. It's not a proof contradiction. It's a contradiction. But you cannot say that he is lying on the dock.
Yes, BK Mishra, my lord, yes.
Yes.
BK Mishra? Yes.
Yesterday.
Other day lordship made the point.
It is not a fact
Doesn't-
that I have not stated before police that I was assaulted by Sonabashi, Priyonath, Manik Singh with dagger. It is not a fact that I have not stated to police that my wife was assaulted with dagger by Tirtho Mohanbashi Narayan Sarkar. These are all were not stated before police. I have not stated to the police that due to injuries I may not survive, and as such I want to give statement. I have stated that same to the brother of my wife Jyotish Mandal. I used to reside along with my wife and my parents. The name of my mother was Dulali Vishwas, who expired before the day above incident. At the time of occurrence, my house was situated in a 2 bigha plot of land, and there existed 3 houses. In between my house and the house of my father, there was a 10-feet courtyard. On the date of occurrence, I was staying in my house with my wife, my son Ajay Vishwas. My lord, kindly note, Ajay Vishwas' son was also at the time of occurrence, aged about 12 years, and my daughter Nayan Vishwas, aged about 3 years. At that time, my son was studying in class 5. Tirtho Vishwas, Mohanbashi, and Sonabashi are my brothers. Before the day of occurrence, they were living separately. There is a road in between my house and the house of my brothers. Before the incident, we have taken our meal and about to go to bed.
Correct.
However, the lamp was on. So here, till now, we are not sure what is the time gap between his taking meal and the time of occurrence. About half an hour before the occurrence, we take our meal. Now it is clear. Half an hour ago, he took the meal. But the medical evidence of the doctor who conducted the PM report, he says that his intestine contained half digested food and it takes 2 to 4 hours. So it cannot be minimum to, but here he says that half an hour. So it is quite improbable, my lord. The occurrence occurred at about 9 p.m. My father, being old, took his meal before us and went to his bed. At that, there was no electricity connection in our house. The accused persons assaulted us for about 15 minutes. There is a PWD road going in front of our house, and on the other side of the road, the houses of Moran Bishas, Ram Bishas, Dulal Bishas. One Jadu Bishas resides on the eastern side of our house. The residence of my uncle Madhu Bishas is situated at a distance of about 80 meters from my house. All the above named persons have their own families. When the accused persons assaulted me, I tried to run away from them and came out from my house. Lordship, one thing kindly note, earlier in his chief he stated that hearing some sound, he came out from the house, his wife came out from the house, he followed her. But here he says that I tried to run away from them and came out from the house. So it indicates that the occurrence took place inside the house. There is a material contradiction. And raised alarm. At that time, the accused persons were inside my house. So here now it is clear that the accused persons assaulted him inside the house. But during chief, at the inception, he stated that hearing some sound, his wife came out and he followed her. So the occurrence cannot be happened inside the house. My son Ajay Bishas was hiding behind the door of my house. My lord, it is important because there is no other eyewitness, sole eyewitness. So for corroboration, the prosecution must have examined this child witness who was present at the time of occurrence. That is not done, my lord. My house was measuring 16 feet into 11 feet. My son Ajay was not assaulted and he was not suffered any injury. As there was darkness, I was not sure whether my father came out or not after hearing my alarm. After the incident, the accused persons left my house. After hearing my alarm, Madhu Vishwas came first and thereafter I saw my father along with other persons. I have not seen Moran Vishwas, Dulal Vishwas, Ram Vishwas coming to the place of occurrence. I do not know if they visited the place of occurrence after I was shifted to the hospital. At the time of occurrence, I was only wearing one gamusa along with one underwear. I was not wearing any shirt. After arrival of Madhu Vishwas, I came to the courtyard and fell there. And the persons who gathered there gave water on my head, etc. When I came back home from outside, I came to know that my wife has expired. After about 10 minutes, my coming back to the courtyard, 108 ambulance came. At the time, police did not accompany 108 ambulance. The gamusa which I wore on that day, not blood stained. This particular wearing apparel has not been seized. Neither any weapon nor any apparels has been seized by the prosecution. I do not know whether police has seized the blood-stained gamusa or not. The floor of my house is kacha. We were attacked on the veranda of our house. So, my lord, kindly see. Once he says that he came out. Thereafter, he says the accused were inside the house at the time of occurrence. Now he says that we were attacked on the veranda. Veranda is outside of the house.
And blood fell on the veranda.
And our blood fell on the veranda. But that evidence has not been collected by the IO. And it is not proved in the trial court. I had not disputed with my brothers before the incident, but as my father was thinking of distributing the land, my brothers did not agree to that. It is not a fact that the accused persons have not assaulted me and also have not killed my wife. It is not a fact that Priyana, Narayan Sarkar, Manik Singh, Sonabashi have not assaulted me with dagger. It is not a fact that no lamp was on at the time of occurrence in my house. It is not a fact that my uncle Madhu Vishwas has not visited our house after the incident. It is not a fact that after hearing a sound on the day of occurrence, my wife, followed by me, had not come out from our house. So this is the deposition of the injured victim, my lord. Now, the deposition of PW6 is Madhu Vishwas, uncle of the injured victim. I know all the accused persons. I also know the deceased Vishaka Vishwas and the injured Shivashi Vishwas. About 5 years ago, one night at around 9 p.m., I heard hue and cry in the house of Shivashi Vishwas, and I came running to the house of Shivashi Vishwas, and I saw Shivashi Vishwas was lying in the courtyard. So when he come, he is not inside the house, the injured victim, he is in the courtyard of his house and was shouting that his wife has been killed and he was also assaulted. I also had seen Vishaka Vishwas lying dead in the courtyard of the house. I gave water to the head of Shivashi Vishwas. Shivashi Vishwas is my nephew. After some time, one Nitya appeared at the place of occurrence and he stopped one car on the road and through the driver of the car phoned the hospital for ambulance. After some time, ambulance came and we brought Shivashi Vishwas to hospital at Mangoldoi. So he has not stated about the deceased, my lord. He took only the injured victim. On the next day, he was referred to GMCS, Gauhati. I also went to GMCS. The injured Shivashi Vishwas stated in my presence that Narayan, Manik Singh, Priyanath Singh, Tirtho, Mohanbashi and Sonabashi had assaulted him with his wife. Cross-examination, my lord. The distance between my house and the house of Shivashi Vishwas is about 80 meters. At the time of occurrence, I, along with my wife and daughter-in-law, were in our home. The incident occurrence in a summer day in the month of March. My son Lakhan Biswas came home at around 9:30 p.m. In the house of Shivashi Vishwas, he, his wife, and one son and one daughter, and Shivashi Vishwas' father Muchiram used to live. Shivashi Vishwas and Vishaka used to reside in one house, and his father Musiram resides in another house in the same compound. Ojoy, son of Shivashi Vishwas, was about 12 years at that time. At that time, there was no electricity connection in our area. At that time, there was no darkness. It is not a fact that I do not see properly at night. At the place of occurrence, I was for about 15 minutes, and after arrival of the ambulance, I came with the ambulance, and during these 15 minutes, I have not seen Muchiram. At that time, I have not seen Ojoy and Noyan at the place of occurrence. After my arrival at the place of occurrence, Nitya Majumdar came to the place of occurrence. At the time of occurrence, Nitya Majumdar was staying at my home. Till Shivashi Vishwas was taken to hospital, I, along with Nitya Majumdar, were present at the place of occurrence. I came with Shivashi with the ambulance and Nitya Majumdar stayed at the place of occurrence. The residence of Dulal Vishwas and Ram Vishwas are situated near my house. The residence of Jodu Vishwas is situated on the other side of the road of the place of occurrence. Dulal Vishwas, Ram Vishwas and Jodu Vishwas live with their family. After hearing the shouting of Shivashi Vishwas, I came running to the place of occurrence. Shivashi Vishwas was shouting that I am being assaulted, come and save us. After reaching the place of occurrence and after seeing Shivashi Vishwas in injured condition, I also shouted for help. Hearing my shouting, Nitya Majumdar came to the place where Vishaka was lying, blood were seen on the ground. When I was shouting, the son and daughter of Shivashi Vishwas, namely Ojoy and Noyan, were not coming out from their home. I, with the help of Nitya, lifted Shivashi Vishwas to the ambulance. Shivashi Vishwas stated to me about the accused's involvement in the hospital. After about 1 hour, or 1.5 hours of his treatment. I was at GMCH with Shivashi Vishwas for about 5 days, and thereafter other persons stayed as attendants. At the time of occurrence, Shivashi Vishwas was wearing one gamusa and a vest. As blood was coming from the body of the Shivashi Vishwas, I wrapped his body with a gamusa. Police recorded my statement at Mangoldoi Civil Hospital. It is not a fact that on the day of occurrence, Musiram has called me to the place of occurrence. The deposition of Muchiram informant, he stated that he called this particular witness to the place of occurrence, but he denied here. It is not a fact that I did not come to the place of occurrence after the incident. It is not a fact that I have not brought the injured Shivashi to the hospital. It is not a fact that Shivashi Vishwas has not stated to me that the accused persons had assaulted him and killed his wife. It is not a fact that Nitya Majumdar has not come to the place of occurrence after me. It is not a fact that I am deposing falsely that I, along with Nitya Majumdar, stayed at the place of occurrence for about 15 minutes and that I, along with Nitya, lifted Shivashi Vishwas to the ambulance. So he is not an eyewitness of the occurrence. Now PW7. This is a medical officer. On 21/3/10 at 10:15 AM, I examined Sri Shivashi Vishwas, PW5, injured victim. Aged about 37 years, male, village Muamari, PS Mangoldoi, so and so. Lacerated injury on both sides of lower chest and forehead, USG study of abdomen done, and it shows contusion and laceration of liver. Patient was referred to GMCH for better treatment. Injury was fresh and grievous in nature. Exhibit injury report, my signature. Cross-examination. The patient was not treated at Mangoldoi. After giving first aid treatment, he was referred to GMCH Gauhati. The patient was suffering from internal bleeding in abdomen. The patient's flow of blood to the brain is reduced. My lord, kindly note, the patient will in confusion stage. In such a situation, the patient may not answer correctly and coherently. So, the police recorded his statement in such a condition. Now, my lord, PW8. This is the police officer who submitted the charge sheet, I think. On so and so, I was working as an attached officer at Mangoldoi PS on that
This
day. My lord,
injury are lacerated injury,
lacerated injury.
including contusion and laceration of liver.
So laceration of liver, it should be by blunt weapon.
It cannot be.
Blunt weapon,
Liver
liver.
is inside. It
How
would
do you
be
incise a
a
blunt
piercing
weapon?
injury, leading to the laceration in the liver.
My lord, for injury to the liver, there must be outside injury. Otherwise, without outside injury, how a weapon can go to the liver, my lord?
Injury of fresh and liver, the laceration of liver is also contusion, laceration of liver. Is
Outside, no injury, my lord.
That is also true.
outside, no injury.
No.
Let's see the injury.
Laceration
report.
injury on both sides of lower chest and forehead.
60.
Lower chest. Chest.
Weapon is blunt.
Lacerated injury on both sides of lower chest and forehead.
Contusion
No size of injury.
and laceration of liver. Laceration of liver.
If there is any cut injury, there must be size of the cut. That is not there.
Face and grievous. Laceration.
And as per doctor's opinion, weapon is blunt.
Okay.
Liver is your lower chest. Lower chest.
So may I go to PW8, my lord?
Yes.
My name is Mohendra Borai, SI of Police. On 8/6/2011, I was working as an attached officer at Mongoldoy PS. On that day, the OC Mongoldoy PS handed over me the CD in connection with Mongoldoy PS case number so and so to complete the investigation of the case due to transfer of the earlier IO. So he has only submitted the charge sheet. IO of the case, namely Kanak Chandranath. On receipt of the CD and after perusal of the same, I found that the earlier IO had almost completed the investigation of the case, but some accused persons were yet to be arrested. During the investigation, I arrested one accused person, namely Shonabasi Vishwas, and took him in custody and forwarded before the court, while the other accused person, Mohan Vishwas, could not be arrested despite my best effort, as his whereabouts could not be traced out. I had also collected injury report of the injured Shivas Vishwas. Thereafter, having found prima facie case, I had submitted charge sheet against the accused person under section 448, 302, 325, 120B, 109, 34, showing the accused Mohan Vishwas as an absconder. Exhibit 5 is the charge sheet. Cross-examination declined, my lord. Now PW9. This is the IO who conducted the investigation, my lord. I am now working as ASI at Mongoldoy PS. Prior to that, I was working an ASI in Mongoldoy Police Reserve. From the CD, it appears that SI Kanak Chandranath investigated Mongoldoy PS case. No, my lord, he is not the investigator.
But IO is Mohendra Bora. Mohendra Bora.
IO is one Kanak Chandra.
Hmm.
He could not be found. That is why this particular.
Also, Kanak Chandranath.
So, I am now working ASI at Mongoldoy PS. Prior to that, I was working as ASI Mongoldoy Police Reserve. From the CD, it appears that SI Kanak Chandranath investigated Mongoldoy PS
He
case.
passed away on 19/18/9/26.
Yes, my lord.
2016.
Under section so and so. Subsequently, it was resulted in the submission of the charge sheet against the accused persons, namely Mohanbasi Vishwas, Shonabasi Vishwas, Chitra alias Tirtha Vishwas, Narayan Sarkar, Manik Singh, and Priyonath Singh under section so and so. The said SI Kanak Chandranath has already expired on 18/9/2016. Prior to his death, I worked along with him at Mongoldoy PS, and as such, I am acquainted with his handwriting and signature. Hence, I have been deputed to depose in connection with this case in respect of the investigation conducted by late Kanak Chandranath. As per the CD, it appears that the FIR was lodged by one Mochiram Vishwas, and it was received by late Kanak Chandranath as the OC of Mongoldoy PS, and he registered this case, filed Mongoldoy PS case number so and so under section so and so. Exhibit 1 is the FIR, 1-3 is the signature of Kanak Chandranath with his note. As per CD, it appears that the IO late Kanak Chandranath visited the place of occurrence. He also prepared a sketch map of the place of occurrence. Exhibit 6 sketch map, 6-1 signature, which I know. Cross-examination, my lord. I worked with the IO late Kanak Chandranath for a period of about 2.5 years, starting from 2009. The place of occurrence was at Mohamadi village, which is about 3 kilometers away from Mongoldoy PS. The distance between Mongoldoy court and Mongoldoy PS is less than 100 meters. As per the date of occurrence was on 21/3/2010 at 9 p.m. and date of registration of the FIR is 21/3/10 at 9:45 p.m. The IO of the case arrived at the place of occurrence on 21/3/10 at 9:30 p.m. The sketch map was prepared at 10 p.m. on 21/3/10. The IO of the case stayed.
Mr. Olive will take a break for 5 minutes.
My lord. We are on the deposition of PW9, my lord.
Page 25.
Cross-examination part. I worked with the IO of late Kanak Chandranath for a period of
Those you have read, come to 25, we're in 25.
25. As per the CD and the IO did not seize any blood stain from the place of occurrence. So in IO has failed to collect any such material. The IO had not taken any photograph of the place of occurrence. No photograph also taken, my lord. The IO also did not mention in the CD to whom he had met immediately after his arrival at the place of occurrence. 5 numbers of witnesses were examined in total by the IO on the day of occurrence after visiting the place of occurrence. Mosiram Biswas is the informant, Madhu Biswas is the brother of the informant, injured Shivashi Biswas, Jyotish Mandal is the elder brother of the deceased, Pipasha Mandal, and Prabhat Sarkar is the writer of the FIR. It appears from the CD that injured Shivashi Biswas and deceased Bipasha Biswas used to live there with their children. It appears from the CD that PW5 Shivashi Biswas had not stated under section 161 CRPC statement that Narayan Sarkar, Manik Singh and Priyonath Singh had entered into his house on the day of occurrence. PW5 had not stated in his statement under section 161 CRPC that Narayan Sarkar, Manik Singh and Priyonath Singh etc. had assaulted his wife with dagger. My lord, kindly note, PW5 had not stated before police that he was assaulted by Shonabashi, myself, my lord, Priyonath Singh and Manik Singh with dagger. However, he had stated that Tirtho Biswas, alias Chitra Biswas, Mohanbashi Biswas and Shonabashi Biswas, being armed with daggers, entered into his house forcefully and assaulted him at first by Tirthobashi. My lord, earlier I submitted regarding chronology. Kindly see the attack of accused who first attacked. Assaulted by him at first by Tirtho, alias Chitra, with a dagger on his stomach. But earlier he said that it was some other person. Hands and head and caused serious injuries on his person, and then he fell down on the ground. And when his wife Bipasha came to rescue him, then the accused Tirtho Biswas gave a dagger blow to his wife while the accused Mohanbashi and Shonabashi were grabbing her, which resulted the death of his wife on the spot. This is completely a new fact, which is neither stated before the court nor any other witnesses. As because here, may I read this particular portion again, my lord. He had stated that Tirtho Biswas alias Chitra Biswas, Mohanbashi Biswas and Shonabashi Biswas, being armed with daggers, entered into his house forcefully and assaulted him. So here, as per his deposition before police, that the accused persons attacked him first. May I clear to your lordship?
Well, how does the statement sentence start with? PW5 had not stated before police that he was assaulted by so and so, so and so. However, he had stated.
So he
that
stated.
Tirtho.
These are the statement of the witness before the police. He stated that the accused persons entered into his house forcefully and assaulted him. So, till now, no attack upon his wife. He is first attacked, then his wife is attacked. Chitra with a dagger on his stomach, hands and head and caused serious injuries on his person, and then he fell down on the ground. And when his wife Bipasha came to rescue him, then the accused Tirtho Biswas gave a dagger blow to his wife, while the accused Mohanbashi Shonabashi were grabbing her, which resulted death to his wife on the spot. But in the chief of PW5, he stated that hearing some sound, his wife came out and he followed her. But here is completely a contradiction that the accused persons forcefully entered his house armed with weapon.
Yes.
PW5 had not stated in 161 CRPC statement that due to injuries he might not survive and as such he wanted to give statement. PW4 Jyotish Mandal had not stated in his statement recorded under section 161 CRPC that Shivashi Vishwas told him that Priyonath, Manik Singh and Chitra had assaulted his sister and him.
Hmm.
This is the closure of the cross. Now, another doctor evidence is there,
Inquest.
PW10.
Hmm?
This is not important. May I read your honor?
Inquest.
Or I skip my lord.
He's not the doctor, he's a circle officer, executive
Yes, my
magistrate, doing the inquest. Page 26. Twenty-six is not the doctor,
Not the doctor, circle officer.
circle officer.
This is not important, my lord.
Yeah.
He only present at the time of inquest, my lord.
Okay.
Now may I take your lordship to the judgment, my lord. The trial court held that the sole eyewitness, injured eyewitness, he himself is a victim and he is an eyewitness. His evidence suffers from contradiction. It is held by the trial court at paragraph 34, page 12, my lord. May I read, my lord?
Yes, please.
PW5's evidence suffers from police contradiction. He stated before the IO that the accused persons had entered into his house and assaulted him. When his wife came near him to rescue him, the accused persons fell on her and inflicted dagger blows on her persons. This is the police evidence. From his evidence, it has come that the accused persons had prepared with daggers in their hands to assault PW5 and his wife. PW5 also stated that the accused persons attacked him with dagger, but the medical evidence so far the injury of PW5 is concerned is quite opposite. PW7 Dr. Phanindra Chaudhary, who examined PW5 Shivashi Vishwas at Mangoldoi Civil Hospital, found lacerated injury on both sides of lower chest and forehead, and according to him, the injury was fresh and grievous in nature. As per Exhibit 4 prepared by PW7, the weapon used to assault PW5 was blunt. Thus, the medical evidence belied the oral evidence of PW5 regarding the injuries sustained by PW5. Your lordship is correct that there is a blunt side of dagger, but there are several injuries. So it is improbable that all the injuries may be caused by the blunt side only. There is not a single injury.
If you are using the blunt side, all injuries will be caused by blunt side. You can hold a dagger on the sharp side, you can hold a dagger on the blunt side.
Nothing can be denied, my lord. Maybe, but it is improbable. There are 4 or 5 injuries stated. All the injuries are blunt. It cannot be, my lord.
It was not a mutual fight that you haphazardly use your weapon. It was not a mutual fight. It was an attack on two persons who were sleeping. So it's not necessary that there will be random use of the weapon. They may use the blunt side.
Usually, that is true.
And many occasions we have seen that blunt side are used. But still it causes grievous injury, it causes death also, but not incise injury. You have seen.
The
Yes.
accused persons have used the sharp side for killing a woman, but on the other hand, the other injury is used only by the blunt side. It is something improbable, my lord, from my understanding. Paragraph 35, my lord. Before this court, PW5 Shivashi Vishwas has stated that on the day of the incident in the night, hearing a sound in the outside of his house, his wife came out. He also followed her. Coming outside of his house, he saw his wife being attacked by the accused persons, which I earlier stated before your lordships, that my submission are that chronology of the attack and chronology of attack by accused. These are separate before the police and before the court. Coming outside of his house, he saw his wife being attacked by the accused person. The accused persons also assaulted him with dagger on his chest. The accused Manik Singh attacked him with dagger. From his evidence made before this court, it appears that his wife was first assaulted by the accused persons and thereafter he was assaulted. Thus, the version made before the police and version made before the court by PW5 are contradictory to each other. But this contradiction fails to touch the core of the prosecution case so far murder of Bipasha is concerned. It is proved that the accused person visited the house of Shivashi on the fateful night. Why did they come? There is no explanation from the accused persons. My lord, my humble submission is that if there is corroboration, then it is a separate matter. There is no corroboration, only on the basis of sole witness I am convicted. While there is other evidence present, but the prosecution fails to examine that witness. And the chronology are also not matching with the evidence of police and evidence before court. Chronology of attack and chronology of attack by accused. Thereafter, learned trial court held that though there are some contradictions in the evidence of PW5, but it remains that in that incident he sustained injuries and he had to take medical treatment in Mongoldoy Civil Hospital, then in GMCH Gauhati. The deceased Vishaka Vishwas is his wife. A close relative generally does not allow the real culprit to escape from the tentacles of the law, and the witness who is a victim or injured hardly leaves the real assailant and robs a person not associated with the crime. A testimony of an injured witness bears high value than any other witness. This is correct, but my submission is that while the evidence is suffering from contradiction, then for conviction, the court should not be gone into assumption, my lord. My lord, I am not taking much time of the honorable court. Now I am summing up my submission, my lord. My submission, first submission, I have already stated that eyewitness not examined, although it was present on the face of the record. Then, my lord, chronology of attack.
Also an eyewitness, but the other, the child, yes.
Child, my lord.
Child could have been examined, no doubt.
My lord. Then, my lord, chronology of attack upon injured and victim, both. Because the witness who is the husband of the deceased, himself being injured victim, stated before police that first he was assaulted. When he fell down on the ground, the deceased came in rescue while she was assaulted with dagger to her death. But before court, he stated that first the deceased was assaulted with dagger and thereafter he himself was also assaulted. Then my third submission would be place of occurrence. The PW5 victim injured stated before police that the accused persons forcefully entered into house and assaulted them inside. Whereas in court, he stated that upon hearing some sound, the deceased went out from the house followed by him while they were assaulted outside their house. Both cannot be correct, my lord. Either they are assaulted inside the house or outside. Then my fourth submission is that chronology of accused in attacking. PW5 stated before police that first he was assaulted by Tirtho Vishwas. And thereafter, Tirtho Biswas gave a dagger blow to the deceased while she was being grabbed by Mohanbashi and the appellant, resulting to the death of the deceased. But in court, he stated that I attacked, the appellant attacked. Then, my lord, injury discrepancy are there. The injured victim, as PW5 stated in the court, that he was assaulted by dagger on his stomach, but the medical evidence shows that his injuries are caused by blunt weapon, my lord. Then investigation lapse, my lord. Police did not seize anything from the place of occurrence, my lord. This is a case of 302, my lord. I am convicted for life imprisonment, my lord. So trial court did not consider all these, my lord. Then reliability of witness, my lord. My submission, last submission would be that reliability witness. There are catena of decisions by the apex court that witness deposed something before the trial court, but the same was not stated before police. He is not a trustworthy witness, my lord. I am submitting, my lord. So, such a untrustworthy sole witness cannot be the sole ground for conviction, my lord. I am, sir, my authority is one apex court judgment, my lord. This is a small judgment, my lord, 2001 10 SCC 754. Torun alias Gautam Mukherjee. I am not reading line by line. May I take directly to second page, paragraph 3, my lord.
Paragraph?
Paragraph 3, my lord, page 2. Lordship got it.
Yes.
To appreciate this contention, we have ourselves scrutinized the evidence of PW 2, 4, and 5. The maid servant PW 4, who deposed in her evidence in chief that the fact that the accused used to assault the deceased almost daily on the instigation of his sister, but in the cross-examination, it has been elicited that she has not stated so in her statement to the police recorded under section 161 CRPC. Such material omission would discredit her version in court. So he is not a trustworthy witness, my lord. If his statement before police and deposition before court does not match, my lord. And in this instant case, my lord, on the basis of sole witness, I am convicted, my lord. No corroboration is there. While the said witness suffers from contradiction that is already held by the trial court. But ignoring that, I am convicted, my lord.
Only one person was convicted.
Yes, my lord.
Only one person.
Only one.
Mohan Bashi, Tirtha, they were acquitted.
They were acquitted. And in the item 29, against them, the appeal has been filed against their acquittal.
But more than one person was present at the time of the offense, isn't it?
Yes, my lord.
That is almost proved.
That is almost proved.
Then.
But who attacked and for which attack the
common
deceased
intention.
died, this is not.
Anyway, so all were acquitted except this.
Except him, all are acquitted.
So he has challenged the acquittal of Anyway.
So I pray benefit of doubt, my lord. Anything further? I have to satisfy Lord.
Come back.
My lord, I am deeply obliged. I am closing my lord. If any further clarification is required, I am ready, my lord.
Case in hand, your lordship will judge whether the evidence of injury on my witness is reliable and trustworthy, your lordship. May I take your lordship to the evidence of PW5? Lordship happens to be the injured eyewitness, your lordship. At page 17. I know all the accused person, but this is Visakha was my wife. Incident occurred on 6th day of month of Chat in the year 2010 on a Sunday. At about 9 p.m., the incident occurred after taking our meal. At that time, after hearing a sound outside our home, my wife, Vishakha, first came out from the house, followed by me. At that time, Tirtha, Mohanbasi, Sonabasi, Narayan Sarkar, Manik Singh, Priyanath Singh assaulted my wife with dagger in her neck, stomach, face, and thereafter also assaulted me with dagger on my forehead, chest, stomach, and also on my hand. I was first assaulted by Sonabasi on my stomach by dagger. The accused Priyanath also assaulted with dagger on the chest. At this stage, the witness, by removing his shirt, has shown the injuries to the court. The accused Manik Singh has assaulted me with dagger, though he attempted to assault on my neck. I have seen my wife being assaulted first by Tirtha with dagger and then by Mohanbasi and then by Sonabasi with dagger. My wife was also assaulted by Narayan Sarkar with dagger. Tirtha Biswas is my younger brother. My injuries were attended by doctor at Mongoldo Civil Hospital, and thereafter I was shifted to GMCH where I was treated as an indoor patient for 10 days. Cross-examination. Police recorded my statement in Mongoldo Civil Hospital. After police was called to the hospital, as I was in serious condition, it is not a fact that in my 161 CRPC statement, I have not stated that Narayan Sarkar, Manik Singh, Priyanath Singh had entered into my house on the day of the occurrence. It is not a fact that I have not stated before the police that Sonabasi, Narayan Sarkar, Manik Singh, Priyanath Singh, etc. had assaulted my wife with dagger. It is not a fact that I have not stated before the police that I was assaulted by Sonabasi, Priyanath, Manik Singh and with dagger. It is not a fact that I have not stated to police that my wife was assaulted with dagger by Tirtha, Mohanbasi and Narayan Sarkar. I have not stated to the police that due to injuries I may not survive, and as such I want to give statement. I have stated that same to the brother of my wife, Jyotish Mondal. I used to reside along with my wife and my parents. The name of my mother was Dulali Biswas, who expired before the day above incident. At the time of the occurrence, my house was situated in a 2-bigha plot of land and there existed 3 houses. In between my houses and the house of my father, there was a 10-feet courtyard. On the date of occurrence, I was staying in my house with my wife, my son Ajoy Biswas, aged about 12 years, and my daughter Nayan Biswas, aged about 3 years. At that time, my son was studying in class 5. Tirtha Biswas, Mohanbasi, and Sonabasi are my brothers. Before the day of occurrence, they are living separately. There is a road in between my house and the house of my brothers. Before the incident, we have taken our meal and about to go to bed. However, the lamp was on. About half an hour before the occurrence, we took our meal. The incident occurred at around 9 p.m. My father, being old, took his meal before us and went to his bed. At that, there was no electricity connection in our house. The accused persons assaulted us for about 15 minutes. There is a PWD road going in front of our house, and on the other side of the road, the houses of Moran Biswas, Rama Biswas, and Dulal Biswas. One Jadu Biswas reside on the eastern side of our house. The residence of my uncle Madhu Biswas is situated at a distance of about 80 meters from my house. All the above named persons had their own house, families. When the accused person assaulted me, I tried to run away from them and came out from my house and raised alarm. At that time, the accused person were inside my house. My son Ajoy Biswas was hiding behind the door of my house. My house was measuring 16 feet to 11 feet. My son Ajoy was not assaulted and he has not suffered any injury. As there was darkness, I was not sure whether my father came out or not after hearing my alarm. After the incident, the accused person left my house. After hearing my alarm, Madhu Biswas came first, and thereafter I saw my father along with the other person. I have not seen Moran Biswas, Dulalini Biswas, and Ram Biswas coming to the place of occurrence. I do not know if they visited the place of occurrence after I was shifted to the hospital. At the time of occurrence, I was only wearing one gamusa along with one underwear. I was not wearing any shirt. After arrival of Madhu Biswas, I came to the court and fell there, and the persons who gathered there gave water on my head, etc. When I came back home from outside, I came to know that my wife was expired. After about 10 minutes, my coming back to the courtyard, 108 ambulance came. At the time, police did not accompany 108 ambulance. The gamusa which I wore on that day got blood stain. I do not know whether police has seized the blood stained gamusa or not. The floor of my house is kacha. We were attacked on the veranda of a house and our blood fell on the veranda. I had no dispute with my brothers before the incident, but as my father was thinking of distributing the land, by my brothers did not agree to that. It is not a fact that the accused person had not assaulted me and also had not killed my wife. It is not a fact that Priyana, Narayan Sarkar, Manik Singh, Sonabasi have not assaulted me with dagger. It is not a fact that no lamp was on the time of occurrence in my house. It is not a fact that my uncle Madhu Biswas has not visited our house after the incident. It is not a fact that after hearing a sound on that day of occurrence, my wife followed me and had come out from our house. Now, your lordship will see, although where eyewitness account is there, motive is not a factor, but in the case in hand, your lordship, here, my lord, PW5, who's
Some motive has also emerged
yes,
because they had some dispute over
yes, lost
the
over
fathers distributing the land.
yes, and
Anyway,
PW1, who happens to be the father of PW5 as well as this was Sivasi Biswas, he has also saw them running away from the place of occurrence. If your lordship sees the evidence of PW1,
He did not name.
he did not name. I've
He
seen
saw
five persons
five persons running away.
running away. He says so, my
Who?
lord.
CW1.
Yes. The learned trial court has overlooked the contradiction in the sequence, as he has pointed out.
Yes. Probably, lordship, there is since it's the case of 3 to 34. Probably acquittal also, as regards the acquitted person, is wrong, my lord. Lordship, taking into account the evidence of PW5, vis-a-vis the injury report, my lord, at page 67, your lordship, which really corroborates your lordship.
PM report is there, no? PM report.
Yes, yes.
It's also there.
Page 65 is the opinion.
Yes.
What kind of?
PM report, page 65, my lord.
65 is the opinion. It starts at page 61.
Yes, my lord, 60.
60.
Sharp pointed object.
Yes.
Pointed object.
Death is due to hemorrhage and shock as a result of injuries sustained as described. All the injuries are antemortem and caused by sharp-pointed object homicidal in nature. So, if your lordship sees the injury, wounds, position, and injury, one incise injury of size so and so in presence so and so on the vital part of the body, your lordship, neck, my lord, and above thyroid cartilage extending from one sternocleidomastoid bone to another, cutting all the deep structure in the anatomical region. Injury number 2, one penetrating injury of size so and so. Then injury number 3, one incise injury. Injury number 4, one incise wound present so and so.
Penetrating the liver.
Yes. And it's on the vital part of the body, your lordship.
These injuries can be caused by dagger.
Yes. And the injury, my lord, on the
Dagger.
victim, eyewitness, your lordship, at page 67. It is on a lacerated injury on both sides of lower chest and forehead. Then there was study of whole abdomen shows contusion and laceration of liver, and fresh and grievous, which is fresh and grievous in nature. And doctor who lordship treated this one injured, His evidence is also there, my lord, at SPW 7, your lordship may kindly have a look. Page 22. On 21/3/2010 at about 10:15 AM, I examined Shibasi Biswas, is it about 37, male, village so-and-so, lacerated injury on both sides of lower chest and forehead, USC study of abdomen done, and it shows contusion and laceration of liver. Patient was referred to GMCs for better treatment. Injury was fresh and grievous in nature. So, Lord, he examined, and apparently, my lord, the evidence given by PW5 can be taken to be account, your lordship, in order to uphold the conviction, my lord. Since he has received injury, lordship, and the presence of PW5, he was very much there as a witness the occurrence, my lord. And lordship will kindly see, they have accused person trespassed into the residence of this one, my lord, victim, as well as both the victims, my lord, PW5, as well as the victim who has died, my lord. Then, your lordship, along with weapon, they have entered, my lord. And since there's a land dispute, your lordship, they have come in order to attack them, your lordship. And PW1 has shown them absconding. Also, he has not named them precisely, but he has seen the accused persons, my lord. Presence of accused person, although he did not identify, but your lordship, apparently, my lord, one of them was his son, my lord. PW1's son, and one is the brother, my lord. Why would anyone name him, your lordship, if there was nothing, my lord? There may be, lordship, lapses on the part of the prosecution, but whether it would, lordship, falsify the prosecution, my lord, case, my lord, when eyewitnesses account is there. Lordship, may I refer one judgment as reported in 2016 assistant.
Madam, we have to meet the submission of Mr. Alim.
Yes.
He has made a certain gist of his argument. First, he says that the chronology of the attack
Yes.
is not consistent, is not matching. Who attacked first
Yes.
and whom the attack was done first.
Yes.
Both from the side of the victim and from the side of the accused
It
person.
may not be necessary, your lordship, because your lordship,
No, no.
whether
First,
yes.
let us understand the question that
Yes.
is answered. Then he says that the available eyewitness, namely the child, was not examined.
Yes.
Third is that evidence which are on record suffers from contradiction. And he has also made an argument that the place of occurrence is also not consistent. Once you say that you went out, once you say it was inside, once you say it's in the veranda. And the use of dagger vis-a-vis the injury suffered by the PW5, that it has been said to be a blunt weapon, is also not matching. And there is no seizure by the police from the place of occurrence. And therefore, the reliability on the witnesses are doubtful. That is in gist his submission.
Lordship.
With permission of the Honorable Court, may I point another point, my lord? As per the PM
You have to
report-
make your submission not in installment, Mr. Alim. You should.
Sorry, my lord. This particular point I have missed, my lord. Although I mentioned.
Which one? Which one?
As per the PM report, the stomach contained partially digested food.
That time. Time you have indicated 9 p.m. whether it's 4 hours can be digested. That may not be a very relevant issue, but yes, but you have to meet the
Yeah,
broad issues.
Regarding the non-examination of the son, both of them were young. One son was there, one daughter was there. So
Daughter was 3 years.
3 years. So
but
when
some-
it is fatal to the prosecution case, my lord,
Yes.
when eyewitnesses account is there, that to an injured eyewitness who stands in a better footing than the eyewitness, my lord, who has suffered injury at a time because of the commission which has taken place, my lord. Regarding the other part, regarding inconsistency as regarding the place of occurrence, may I take your lordship to evidence of PW5 once again?
The question is actually, before us is that whether there are some infirmities in the testimony of PW5, which has also been noticed by the trial court. Now, the question is whether those infirmities are fatal to the prosecution. That's the thing.
Yes,
What is the degree of
my respectful submission is that it's not fatal to the prosecution case, and the place of occurrence, your lordship will see, this PW5 eyewitness, he has seen, he has, lordship, he has stated somewhere, my lord, he has come out. So, lordship, there's a possibility, lordship, that the occurrence had taken place both inside as well as in the courtyard, your lordship, in the baranda. Somewhere he has stated, my lord, just now I have read it.
But this also cannot be overlooked that there has been death of one person
Yes.
by very serious piercing injuries.
Yes. So I say your lordship made the submission.
But who caused it? That's the
Yes,
question.
who caused it may not be required since it's a case of 34.
No. Who caused it? Because would be necessary in this appeal because the others have been acquitted, right? We are not going into the acquittal
Yes.
aspect now.
So,
So Sonabasi, whether the presence of Sonabasi is proved. That is the question.
yes.
Appellant is Sonabasi.
Proved, your lordship, he has specifically named my
That is
lord.
the issue in this appeal. Whether any assault on the injured or deceased by
Yes.
the, especially the deceased, 302 is there, by the appellant emerges,
My lord.
and whether it can be accepted, as has been accepted by the trial court, despite the contradictions in PW5.
Lordship, there's a line in a cross-examination. All the above-named persons have their own families. When the accused person assaulted me, I tried to run away from them and came out from my house and raised alarm. So there's a possibility that the lordship, the occurrence had taken place both inside and outside the house, my lord. At that time, the accused persons were inside my house. My son Ajay was hiding behind the door of my house. My house was measuring so and so, was an assault, and he has not suffered any. As there was darkness, I was not sure whether my father came out and not after hearing my alarm. After the incident, so and so. So, Lord, the presence of accused person well proved. But whether the occurrence had taken place inside or outside, your lordship will kindly see from the deposition of PW5, the occurrence had taken place both inside as well as outside the house, your lordship. And regarding the inconsistencies, your lordship, as regards the medical as well as the testimony of ocular, my response submission, the ocular evidence is there may be some, this is a suggestive in nature, my lord, the evidence of doctor. So there may be some discrepancy.
No, the weapon has also not been seized.
That may not be there, your lordship. All the
No,
case, lordship is.
no, on this issue, whether it's a blunt weapon or a sharp weapon, weapon has not been seized. The medical, so far as PW5 is concerned, says it's a blunt weapon.
Hello.
So far as the deceased is concerned, it's called a sharp weapon. Since more than one person is involved, it's possible that somebody was using a blunt weapon, somebody was using a sharp weapon. But the aspect, another aspect is that PW5 says that hearing a noise, wife went out,
Yes.
followed by him.
Yes.
Wife was attacked first, causing the death, and in the meantime, he was also attacked. That is, and before the police, he says that they trespassed into the house and attacked him first. Wife tried to save him, then she was killed. That is the version of the police. If you come to PW
8 and 9 are the IOs.
PW9.
PW9
Yes,
at page 25.
Yes.
25, kindly come to 25.
Lordship.
However,
However,
first he
yes,
said, first the negation. PW5 has now stated in his statement that so and so had assaulted his wife with dagger. P has not stated before police that he was assaulted by so and so. However, have you seen?
yes,
However,
he had
he has
stated that.
stated that Tirtha, Chitra, Mohanbasi, and Sonabasi, being armed with weapons, entered into his house forcefully and assaulted him at first by Tirtha with a dagger on his stomach, hands, head, caused serious injuries on his person, and then he fell down on the ground. And when his wife Bipasa, this should be not Bipasa, this should be Visakha.
Bishop.
Visakha came to rescue him. Then the accused Tirtha Viswas gave a dagger blow to his wife while the accused Mohanbasi were grabbing her, which resulted in the death on the spot.
Yes. I don't find any inconsistencies as regard the statement made by PW5, Your Lordship.
PW
General, because Lordship see land dispute amongst brothers.
PW5 also. You come to PW5, madam.
My lord.
PW5, his narration.
Yes.
Third line. At about 9 p.m., have you got page 17? The
Yes.
incident occurred after taking our meal. At that time, after hearing a sound outside our house, my wife Visakha first came out of the house, followed by me. At that time, Tirtha so-and-so assaulted my wife with dagger in her neck, stomach, so-and-so, and thereafter also assaulted me.
Yes. Little bit of inconsistencies here and there.
And the place
Yes.
outside. Here they came inside, attacked me first. Wife came to save, wife was killed.
Hey, see the 161.
Please. But there's a group, so that group when all of them attack, so some inconsistency cannot be said to be fatal in all cases.
34 or
34 is there.
34, 1, because the others are equated. Yes. And of course, it is subject of challenge.
More naam, statement of injured persons is Sibashi Biswas. More naam ঠিকনা সোধাত ওপৰত লিখা মতে মই কোৱা হয়। মোৰ বয়স বৰ্তমান 35 বছৰ। জীৱিকা খেতি আৰু হাজিৰা। মোৰ গোচৰৰ ঘটনা সম্পৰ্কে সোধাত মই কওঁ যে আজি ইংৰাজী 21 শ্ৰেণী 2010 তাৰিখে ৰাতি অনুমান 8-9 মান বজাত মই খোৱাৰ উদ্দেশ্যে বিচনাত উঠাৰ লগে লগে মোৰ নিজা ভাই ক্ৰমে শ্ৰী তীৰ্থ বিশ্বাস ওৰফে চিত্ৰ বিশ্বাস, শ্ৰী মোহনবাসী বিশ্বাস আৰু শ্ৰী সোণাবাসী বিশ্বাসে হাতত ডেগাৰ লৈ মোৰ ঘৰৰ ভিতৰত বলপূৰ্বক প্ৰৱেশ কৰি প্ৰথমে মোক চিত্ৰ ওৰফে শ্ৰী তীৰ্থ বিশ্বাসে ডেগাৰে পেটত, মূৰত আৰু হাতত ঘপিয়াই গুৰুতৰ জখম কৰাত মই মাটিত পৰি যোৱাৰ লগে লগে মোৰ পত্নী বিশাখা বিশ্বাসে বাধা দিবলৈ লওঁতে মোহনবাসী আৰু সোণাবাসীয়ে তেওঁক সাৱটি ধৰাত চিত্ৰ ওৰফে তীৰ্থ বিশ্বাসে মোৰ পত্নী বিশাখা বিশ্বাসক ডেগাৰেৰে হানি ঘৰৰ ভিতৰতে হত্যা কৰি পলাই যায়। মাটি বাৰী লৈ মোৰ ভাই কেইজনে আমাৰ নিকটৱৰ্তী পদকীয়া ক্ৰমে নাৰায়ণ চৰকাৰ, মানিক সিং আৰু শ্ৰী প্ৰিয়লাল সিঙৰ উচতনিত মোৰ ভাই কেইজনে এই জঘন্য হত্যাকাণ্ড সংঘটিত কৰে। তথ্য একো নাই, অন্য কাৰণ একো নাই, মোৰ ক'ব লগা নাই।
In the 161 statement, the dagger blow on the deceased is attributed to Tirtha Biswas. And the others were holding.
Yes. But 34 is there, Lordship.
34 is there. But in the deposition, he has stated separately. He has stated that Tirtha stabbed with dagger.
Yes.
Then Mohanbasi, then Sonabasi
Yes.
with dagger. and also Narayan Sarkar.
Date of incident is 2010.
He was examined 7 months after the incident. PW5 was examined 7 months after the
But
incident.
deposition is in 2015, madam.
Yes, yes.
After 5 years, so.
Oh, sorry, sorry, yes, sorry. It was,
Lordship,
sorry, it
there
was
may be
5 years
increase-
after the incident.
Madam,
That's a long time.
long time. So there may be some inconsistencies here and there.
2010, I thought.
And yes, your lordship, whether
The
it will be-
PM of the deceased, that page 60, number of injuries are 5.
Repeatedly stabbed
yes,
by someone.
yes.
Including liver.
So I say,
Left
my
angle
lord,
of
maybe
mouth.
lordship, acquittal of this person is also wrong, madam.
Wrist.
That's of course, it's open mind.
Wrist, left side, just over. Wrist.
They were acquitted mainly because it was not stated in the 161 statement, mainly because of that, I think.
No problem. Poor. It's something very poor. In the judgment.
No, no, that's a discussion.
This 53, 34, 35.
The motive is well proved, my lord. They came with weapon, they trespassed into the residence. Maybe not lordship, if considers there are inconsistencies, but it is the residence of the victim, my lord. Land dispute factor has come to light, your lordship, come up in evidence. Lordship, any other query? Lordship, may I cite one judgment, 2016-16 SCC 164? Only the relevant portion, para 11, my lord. 16 SCC 164, Kamta Yadav and others was the state of Bihar, para 11. We have already narrated, lordship, font was very small, that's why they could not take on. So, para 11. We have already narrated a deposition of the witnesses in brief. There are 6 eyewitnesses and 3 of them are injured eyewitnesses, which is a weighty factor to show the actual presence of these witnesses at the scene of occurrence. Moreover, the credibility and trustworthiness of all these eyewitnesses could not be shaken by the accused person. Once it is found that these witnesses were eyewitnesses were present and they have truthfully narrated the incident as it happened and their deposition of what credence, conviction can be based on the testimonies even if they were related to the deceased. The only requirement while scrutinizing the interested witnesses is to examine their deposition with greater caution and deeper scrutiny is needed, which exercise has to be done by both the courts below. In fact, when a learned counsel for the appellants was confronted with the aforesaid factual legal position, he could not even provide any answer to the same. Although my learned has not taken the plea, this witness is an interested witness, but at the face of it is related, my lord. Another citation, my lord. Two 2002, 7 SCC 536. Samsher Singh versus State of Haryana. 536. Lordship, para 3, The learned senior counsel for the appellant urged that in view of the conflict and inconsistencies between the evidence of eyewitnesses and medical evidence. Lordship? Oh, copy, just now. No.
Subsetting citation.
Lordship?
Para 3.
Yes, the learned senior counsel for the appellant urged that in view of conflict and inconsistency between the evidence of eyewitnesses, medical evidence, in the absence of direct motive behind the appellant and the deceased, non-examination of another eyewitness, Sadbir, and the interested testimony of eyewitnesses being related to deceased, both the courts committed serious error in convicting and sentencing the appellant. He drew our attention to the statements of PW 7 and 8 and the statement of doctor to point out that PW 7 and 8 had stated that the appellant assaulted the deceased on his head with the axe using its sharp edge, and that the doctor had specifically stated that the injuries sustained by the deceased could not have been caused by any sharp-edged weapon. In view of the specific evidence of the witnesses, this court ought not have relied on the evidence of the eyewitnesses. As to the motive, he submitted that in the incident alleged to have happened 6 or 7 days earlier, leading to the quarrel between Suresh and cousin of the deceased and the accused, the appellant was not present at that time, and there was no direct conflict between the appellant and the deceased. Thus, the so-called motive did not support the case of the prosecution. When the deceased and his father, PW7, had gone to shop of Sadbir, and when Sadbir was very much present at the time of occurrence, his non-examination was fatal to the case of the prosecution. Lordship, I'll come to the finding. It's in para 8, my lord. Para 8, subpara second, second, my lord. These decisions cited by the learned counsel appellant are related to those cases where medical evidence and the person of the eyewitness could not be reconciled, or the account given by eyewitnesses or the incident was highly or patently improbable and totally inconsistent with medical evidence, having regard of facts and so, as such, the evidence could not be believed. Lordship, I'll come into. Para 8, my head side.
Reply.
We will complete this. The second of this court will not say.
Lordship.
Complete.
Right. The authority cited by the learned counsel for appellant on the point of when there is a conflict between medical evidence and the ocular evidence, the prosecution case should not be accepted or of no help to him in this case. On deeper scrutiny of evidence as a whole, it is not possible to throw out the prosecution case as either false or unreliable on mere statement of a doctor that injuries found on the deceased could not be caused by a sharp-edged weapon. This statement cannot be taken in isolation and without reference to other statement of the doctor that the injuries could be caused by so-and-so acts to disbelieve the evidence of eyewitnesses. From the evidence available in this case, the possibility of the blunt head of the axe or the stick portion coming in contact, this cannot be ruled out. So when eyewitnesses account is there, it will prevail over the medical evidence, my lord, which is most of the time suggestive in nature, your lordship. So considering the facts and situation of the instant case, your lordship must uphold the conviction, your lordship. And regarding lordship lapses on the part of the prosecution, my lord, your lordship, finds in each and every case there is some lapses or the other. Lordship, if it doesn't go into root of the prosecution case, then your lordship will uphold the conviction. My respectful submission is that. With your voice.
Mr. Khan, where did the account? I did that.
Oh, okay.
Well, this appeal is presented against the order whereby the bail application of the petitioner has been rejected by the Special Judge Bongaigaon Lordship. The matter is still under trial lordship, and 25 witnesses are there, and 5 witnesses have been examined. And the petitioner is behind the bar for lordship 3 years, 11 months, and some 5 days, almost 4 years. And lordship, the charge under section lordship 19, Unlawful Prevention Act is there. And only because of that, the lordship he has not been released on bail. And on the other hand, lordship, the prosecution has taken time to complete the process. I have annexed all the lordship order sheet. Lordship, if your lordship is pleased to go through that order sheet, your lordship will find that.
But you have not even taken steps for service of notice.
Notice lordship, they have a hearing.
There's a office for step for service of notice has not been taken.
Not,
Why did they make the assignment to a party?
no, they only the formal party. Lordship, they are appearing. There is no.
In order of the courts. There's a office for.
Lordship, as both the respondent are represented on that ground. Name informant is the police officer, lordship. That's why my friend is.
Party. Not even taking steps. Must take steps. If you're not served for some purpose, then you still see. You're not even taking steps.
If you today itself, lordship, I take in the next week. Because yes.
How we have come back asking for the Apple also heard that we have that is it the SF parents office number 25/2026 reflects that steps for service of notice have not been received by the concerned section parent. The economy is counsel for the appellate submits that you take steps during the course of the
Itself, today itself, lordship, I sub to my friend, lordship, because.
To office.
Well, if 2 is police officer, lordship, my friend will represent, lordship. Already name is there, but.
Binding police notice.
You cannot force them to.
No, I cannot.
PC accepts, it's a different matter.
Lordship,
Has it been
binding.
a police of the advice?
Designation.
By only by designation, we will ask her to.
I have given lordship a here Gogigova police station. Anyway, it will take time, lordship, otherwise only.
We take steps by Monday. By Monday.
Yes.
List Monday by in the manner prescribed. A list on when.
Any date, lordship, before lordship, can it be possible, lordship? 7 and.
Before we move. 6 to 10, not be possible. We'll have you on 22nd of April, but do it immediately, okay?
Well, through speed post, lordship, that means.
That will be fine. Okay. Oh, he will come here for you. Yeah.
Be segregated.
So we
Oh.
there do this
This.
was along with criminal experience. We have noticed, and apart from the fact that the land council or the appellant is not present. From what we have noticed. Managers of the appellant or. Yes. Be present for this case. If there is a in the instead of order of the field. And it is listed along with people, which, however, which is an appeal against the conviction. We have also noted that Current counsel for the appellation is on. And I have also been informed that the land of the appellant is on maternity leave, considering that the judge is against another comma. The same stands segregate from one of the sense which has been heard. This after.
List after a month, you know?
1 month, this will go on in item number. Item number 29. 28. Second of this code will not.
Single.
No, single also will not.
I'll.